Hello everyone. In the previous presentation, clause 1 of section 32 covering statements relating to the cause of death, that is, the dying declarations, was explained. This presentation will explain the rules under clauses 2 to 8 of section 32 and section 33, which also deal with relevancy of statements by persons who cannot be called as witnesses. Clause 2 of section 32 makes relevant a statement by any such person referred to in section 32, provided the statement is made in the ordinary course of business, and in particular when it consists of any entry or memorandum made by him in the books kept in the ordinary course of business, or in the discharge of professional duty, or of an acknowledgement written or signed by him of the receipt of money, goods, securities, or property of any kind, or of a document used in commerce, written or signed by him, or of the date of a letter or other document usually dated, written, or signed by him. For example, where the question is as to a person's date of birth, an entry in the diary of a deceased surgeon regularly kept by him in the course of business, stating that on certain date he attended that person's mother and delivered her a son, is relevant. Here the statement is made by the surgeon who is dead and cannot be called as a witness. The date of delivery of the person was made by the surgeon in his diary in the course of his business and in discharge of his professional duty. The evidence of such entry would be admissible under clause 2 of section 32. Now clause 3 of section 32 makes admissible a statement made by person belonging to any of the four categories referred to in section 32 if the statement is against the pecuniary or proprietary interest of the person making it, or when, if true, it would expose him or would have exposed him to criminal prosecution or to suit for damages. The principle on which such a statement is allowed to be proved is that no man is likely to make a statement against his own interest. For example, the question is whether A and B were legally married. The statement of admission made by deceased clergyman that he married them under such circumstances that the celebration would be a crime is relevant. Here the statement is made by a person who is dead and cannot be called as witness. The statement made by the clergyman prior to his death is against his interest, and if true, it would expose him to criminal prosecution. In order to make a statement admissible under clause 4 of section 32, the statement must be made by the person belonging to any of the four categories referred to in the section. The statement must give an opinion as to the existence of any public right or custom, or as to matters of public or general interest. The person giving the opinion must be a person who is likely to be aware of the existence of such a right, custom, or matter if it existed, and the statement giving the opinion must be made before the controversy arose. For example, the question is whether a given road is a public way. The statement made by a deceased headman of the village that the road was a public way is a relevant fact. Here, the question pertains to matters of public right, and the person giving the opinion is the headman of the village who is likely to be aware of such public right if it existed. Clauses 5 and 6 deal with an identical subject with a slight difference. Under clause 5, whenever a statement is made by a person which relates to the existence of any relationship by blood, marriage, or adoption between persons as to whose relationship the person making the statement had special means of knowledge, it is relevant provided the statement was made before the question in dispute arose. For example, where the question is whether A and B are husband and wife, a statement made by a deceased priest that he solemnized the marriage between A and B is relevant. Here the statement of the deceased priest relates to the existence of relationship between A and B, and since he solemnized their marriage, He has the special means of knowledge as to the relationship in question. Clause 6 deals with relevancy of statements as to the existence of relationship by blood marriage or adoption between persons who are deceased. A statement made in this case is made in any will or deed relating to the affairs of the family to which such deceased person belonged, or in any family pedigree or family portrait or such other things. Statements admissible under this clause are statements as to the relationship between persons who are deceased. For example, the question is whether C is entitled to inherit the estate of A, who is claimed to be his deceased grandfather. In order to prove that C is the heir of A, it is necessary to prove the relationship between C's father B, who is deceased, and A, who also is deceased. The statement as to such relationship must have been made before the question in dispute arose. The difference between clause 5 and clause 6 of section 32 is that while clause 5 admits evidence of statements whether they are written or oral as to relationship between persons living and between persons living and dead, clause 6 of section 32 admits evidence of only recorded statements as to relationship between persons deceased or persons who are dead. In both cases, the statement must have been made before the question in dispute as to such relationship was raised. Clause 7 of section 32 admits the evidence of a statement of a person who is dead cannot be found, etc., if the statement is contained in any deed, will, or other document which relates to any such transaction as mentioned in section 13 clause A. Under section 13 clause A, whenever the proof of a custom or a right is in question, evidence can be given of any transaction by which the custom or right in question was created, claimed, modified, recognized, asserted, or denied, or which was inconsistent with its existence. Now, clause 8 of section 32 admits the evidence of a statement made by a number of persons which expressed feelings or impressions on their part to be relevant to the matter in question without calling such persons. For example, A sues B for a libel expressed in a painted caricature exposed in a shop window. The portrait was titled The Beauty and the Beast. A contended that portrait painted was that of his brother and sister-in-law, and it was done to bring them into public ridicule. The question is as to the similarity of the caricatures and its libellous character. Here, the remarks made by the spectators who have gathered at the scene about the similarity of the caricatures and its libellous character can be proved. Section 33 is another exception to the general rule that hearsay evidence is no evidence. In a civil or criminal proceedings, the litigant or the accused has a right that the witness who testifies against him shall personally appear before the court conducting the proceedings. Personal appearance of a witness offers an opportunity to the court to observe his demeanor for the purpose of determining his credibility. When a witness is personally available, he is administered oath before he testifies, and he can also be subjected to cross-examination by the adverse party, and these provide guarantee for the truth of the information. Under section 33, depositions made in a former suit or proceedings by witnesses are allowed to be proved in subsequent suit or proceedings or in the later part of the judicial proceedings without procuring the attendance of such a witness if the witness is dead, cannot be found, or he has become incapable of giving evidence, or his attendance cannot be procured without an amount of delay or expense, or he is kept out of the way by the adverse party. The first four categories are similar to those provided in section 32. The fifth category, which is peculiar to section 33, has been added for the reason that the interest of a party should not suffer if his witnesses who are required to depose in the subsequent judicial proceedings are kept out of the way or are tampered with by the adverse party. The second condition is that the deposition which is sought to be admitted must have been given in a formal judicial proceedings or before any person legally authorized to receive it. Where the court does not have the jurisdiction to decide a particular subject matter, its proceedings cannot be said to be judicial proceedings within the meaning of section 33, and in such cases, any deposition made in such proceedings cannot be admitted. Similarly, arbitration proceedings are not judicial proceedings under the Evidence Act, and hence depositions made in such proceedings cannot be admitted. Depositions made in the previous proceedings can be allowed to be proved in subsequent judicial proceedings, provided both the proceedings have been between the same parties or between the representatives in interest. The issues involved in both former as well as the subsequent judicial proceedings must be identical so that the depositions in the former proceedings can be admitted under section 33. The explanation appended to the section provides that a criminal trial or inquiry shall be deemed to be a proceeding between the prosecutor and the accused for the purpose of the section. Depositions made by witness in the former judicial proceedings can be admitted in the subsequent judicial proceedings, provided the adverse party in the first proceeding had a right and opportunity to cross-examine. Where a witness died after deposing in the first judicial proceedings and the adverse party did not have the opportunity to cross-examine him, the deposition of the witness cannot be used in the second proceedings. But where the adverse party failed to utilize the opportunity of cross-examination, the provision does not apply. Adverse party means a party against whom a witness is produced in the previous proceedings, but not the party who produced the witness and had the advantage of having examined the witness. The purpose of this proviso is to protect the right of the adverse party who did not have the opportunity of cross-examining the witness who deposed against him. Depositions by witnesses before any person authorized by law to take evidence can be proved in a subsequent judicial proceedings under section 33 of the Evidence Act. The Code of Criminal Procedure and Civil Procedure provide for appointment of commissioners for the purpose of recording evidence of the witnesses. The evidence of such recorded statements is relevant in a subsequent proceeding as they are persons authorized by law to take evidence. And this, in brief, is about the rules pertaining to the admissibility of statements made by persons who cannot be called as witnesses under sections 32 and 33 of the Evidence Act. Thank you.